What we're going to do now is to read parts from the Intergenerational Climate Crimes Act of 2021 together. I'm going to quote Jonas in saying that the Court for Intergenerational Climate Crimes is as real as we collectively acted into being. Another way of saying this is that, of course, you can think of it as a fictional court, you can think of it as a performance tribunal, but you shouldn't, because this is as fictional or as real as those fictions and / realities that hold the world in place today. And so we make it real by being here, we make it real by being the audience and the jury, and we will make it real by reading the act together. So I will pass the mic to the first person that volunteers on the first line, someone brave, or I will just have to volunteer you. And then maybe I should tell you what you're going to do. And then you'll just be reading a very brief excerpt from the act from the screen, and then pass the mic to the next person. Thanks, Mary. Pass the mic to the next person next to you. Of course, you don't have to read. Just pass it on if you don't want to. Thank you so much for being here.
An act to abolish intergenerational climate crimes, to establish intergenerational relationships of solidarity and comradeship among human and non-human species, establish the Court for Intergenerational Climate Crimes, and propose measures to remedy the abuse of intergenerational and interspecies relationships in the past by certain persons.
Be it enacted by the assembly of all those present in the name of the human and non-human ancestors, Mother Earth and the cosmos, and by the authority of those present in this assembly in their capacities as the ancestors of future generations.
Intergenerational includes all past, present, and future generations. For the purposes of this act, it is clarified that
the term intergenerational is not limited to a single step in the line of descent from an ancestor.
The meaning of a generation is not limited to 30 years or other definitive numbers of years.
A generation may be of a different length of time for different species.
Interrelational relationships include relationships between humans, between non-humans, and between humans and non-human species.
Persons means any living being subject to the laws of life, i.e. birth, life, death, and regeneration cycles over periods of time as appropriate for each species.
Person does not include a legal person, i.e. legal artifacts conferred with human attributes by the fiat of law.
An intergenerational climate crime is committed when a group of persons acting as a single legal person in the name of a legal entity, as defined in Section 2.4, under laws established by themselves, engage in acts of commission and/or omission, or engaged in such acts in the past, that harm or harmed, destroy or destroyed, violate or violated, or otherwise adversely impact or impacted the conditions necessary for the reproduction of any species, including, but not limited to,
acts of commission and or omission, the past and or present, the harmed, destroyed, violated, or otherwise adversely impacted, whether patterns in the short or long term.
Acts of commission and or omission in the past and or present that harm, harmed, destroy, destroyed, violate, violated, or otherwise adversely impacted weather patterns in the area, making the survival of non-human species difficult or impossible.
Thank you so much for joining us in this reading. I would like to now invite Radha de Souza to speak with us about intergenerational climate crimes in this court.
Thank you. Thank you, everyone. Thank you for being here. Thank you for your support. Thank you for your enthusiasm. Thanks to the Serpentine team, the Westminster team, and of course, our very own Jonas Staal's team, studio team. I would like to thank all of you individually in person, but that will take up most of the 20 minutes allocated to me today. For Jonas and me, today is a very special day to be celebrating this new chapter of the Intergenerational Climate Crimes. Quote, exactly on this day, on the 4th of April, 15 years ago, and it was an Easter weekend, we met for the first time in Hamburg. In retrospect, it is interesting that the meeting that Kurdish communities had called was titled Network for an Alternative Quest. Our comradeship and friendship and collaborative partnership began those 10 years ago, but most importantly, it started the quest for alternatives, for better ways to reimagine the world and for better ways of being in this world. So I say thank you to Jonas, and also I feel I'm very fortunate to have found a fellow traveler. So in the 20 minutes that I have, I want to do 3 things. First, I want to locate the Court for Intergenerational Climate Crimes and its relevance in the contemporary context that we live in. Second, I want to say something about the CICC's philosophical and conceptual foundations and its aims. And thirdly, I want to say something about the special court on intergenerational climate crimes that this iteration that we are opening today, a special court that will focus on intergenerational nature of climate crimes. And that is the reason for putting the East India Company on trial here, to focus on intergenerational aspects. So let me begin with contextualizing the CICC. There is a Chinese proverb that says, may no person live in interesting times. And we are living in very interesting times, sadly. Looking around us, we are witnessing a televised genocide that has been going on for 1.5 years. But we do have a genocide convention that states very clearly that every state and every individual has a duty to take action to stop genocide. Some of you may have filled out visa forms that asks, have you ever witnessed a genocide? Why is that? Because legally we are bound to report something if we have seen it. The International Court of Justice said very clearly, as early as January 2024, that you cannot blockade food, medicines, and water, whatever the political disputes between the parties. The Fourth Geneva Convention of 1949 has a specific section on the legal obligations of an occupying power. Now, this is without going into whether the rightness or wrongness of the occupation itself, regardless of those issues. Section 50 says specifically that an occupying power must, and I quote, facilitate the proper working of all institutions devoted to the care and education of children. It's very, very clear. Article 55 says that the occupying power has a duty to ensure food and medical supplies to the population in the occupied territory. Given these explicit provisions of the ICJ, the ICJ ruling was hardly radical so far as judicial interpretations go, because it's quite explicit. Much of the discussion thus far has centered around what different state actors did or did not do, what they should or should not do. It may be important to discuss these issues, but my point is, can we stop there? Especially in these interesting times. When our questions are not answered, we need to probe the question further. We need to ask ourselves very basic questions about these institutions, such as the United Nations, of which the ICJ is an organ. If we just read the preamble of the UN, and if we read the aims and stop there, the aims are very simple. In a nutshell, it is that we, the people of the world, will strive for peace and prosperity, for equality and self-determination, and human dignity for all. Now, who can quarrel with these aims? No one can quarrel with them. We all want dignity for everyone. That's not even an issue. And so we must dig deeper and ask, why is it that the very moment when the clauses on self-determination were being written in the UN Charter, Palestine was being occupied? Both these events happened at the same time, simultaneously. The occupation and the clauses on self-determination in the UN Charter. Why is it that despite 191 General Assembly resolutions concerning Palestine, the conflict remains unresolved? If anything, it gets worse with each General Assembly resolution on the resolution of the conflict. Now, Einstein famously said that we cannot keep doing the same thing again and again and again when it is not producing the results we want. So when something is not producing results, we need to ask why and go further. Now, if we look very closely at the General Assembly which passed those 191 resolutions, the reasons become less misty. The General Assembly is seen by most people as a kind of world parliament, an assembly of states. It's like where everyone meets. All states meet. However, the General Assembly has no powers to do anything. This many people do not know. It can only make recommendations, and that's all. So next question we need to ask is, how come the General Assembly was established with so much fanfare as the world's representative body, but without any powers to do anything? And to answer this question, we need to peel the layer further back into colonial history. The powers of the General Assembly is modeled on what used to be called the Assembly of Princes under British rule. The British Empire had a hierarchy of states with different statuses, and the princely states or the protectorates had the most autonomy, whereas the settler colonies had the least autonomy. So it was a graded system. The Assembly of Princes was set up to give representation to native rulers in British India in the context of World War I, and I won't go into the reasons here. What is relevant for us today is that the Assembly of Princes was set up with as much fanfare as the General Assembly, as a representative body, but like the General Assembly, it had no powers. The powers were limited to making recommendations. So you know where the model comes from. How is it that an organizational model of the Assembly of Princes under the Empire was elevated to the General Assembly of the United Nations, comprising all those newly independent states? Peel another layer, and we need to ask who wrote the statutes of the UN Charter and how they thought about the representative body. Now, one of the leading figures who was instrumental in the design of the League of Nations and the United Nations that followed the League of Nations was Jan Smuts. Jan Smuts was a lawyer, the Prime Minister of apartheid South Africa, who laid the constitutional foundations of apartheid in South Africa, together with Cecil Rhodes, the mining magnate and owner of De Beers Mining Company that was established with the support of Rothschild & Co. Smuts was then invited by Britain to join the Imperial War Cabinet and later appointed to the drafting committee of the League of Nations and later the United Nations. Smuts says very clearly in his book on the League of Nations that the clamor for self-determination was growing louder everywhere and the empire could no longer ignore it. So he says, we, that is Imperial Britain, should set up a League of Nations that should recognize self-determination in principle, but establish a hierarchy of states with different powers and functions. He says in his book that the constituents of British Empire, such as the Crown Colonies, the Protectorates, the British Overseas Territories, there were various categories of these, they have worked rather well together. So well that they ought to be internationalized as the League. And I quote this because he's very, very clear on what he wanted and what the empire wanted. And it is suggested that where the British Empire has been so eminently successful as a political system, the League, working on somewhat similar lines, could not fail to achieve a reasonable measure of success. You have it from the horse's mouth, as they say. The League of Nations later became a template for the United Nations, where the hierarchy of states was maintained together with the recognition in principle of self-determination of nations. Smuts thought that the United Nations was essential to safeguard the apartheid system in South Africa. He was, after all, a leading member of the drafting committee of the UN Charter, and he understood why that was the case. But my question to all of us here is, why do we think otherwise? Why do we think otherwise? Why do we think that this is a body that is going to give self-determination to anyone? And that is the important question. The Security Council veto is seen by many as unfair because the big five or the permanent five get to veto all decisions. But where did that veto principle come from? And we need to go back to the Napoleonic Wars, which divided the colonies among the imperial powers, and as part of the settlement, introduced the veto principle, which was also known as the Great Powers Principle. Have you wondered why Guantanamo Bay is Cuban territory, but the United States has jurisdiction over it? I could go on about many, many more examples about the protectorate system, the regime change rules, preventive deterrence, and much else that we talk about these days. But I don't want to do this, and I want to turn our attention to the CICC, why the CICC is relevant and what it has to do with all the context that I set up. We are at a historic crossroad. And in the past, at moments such as this, the one that we are in today, people have put the law on trial. National liberation movements put the law on trial. The slaves of Haiti put the law on trial. Working people in this country put the law on trial when they demanded a people's law, and I'm referring here to the Charterist movement. Ho Chi Minh told a French journalist, he said, I went to Vietnam to study law as a law student. And there I learned about liberty, equality, fraternity. I learned that all human beings were equal, they were born free, etc. And I went back to my country and I thought the French meant it. And then, of course, we know what happened to the Vietnamese people after he said that all those things they wanted for themselves as well. Just in the past few decades, we have watched one genocide after another play out before our eyes. Rwanda, Myanmar, Tamils, Palestine, the list goes on, just within the last few decades. If we don't put the law on trial in the situation that we find ourselves at in the present, what else is there for us to do except repeat the same words and the same action over and over again, knowing that the results are not going to be any different? The CICC was born from such questions. The Court for Intergenerational Climate Crimes puts the law on trial. To be clear, it does not put CEOs, politicians, individuals on trial, but it puts the law itself on trial. I will now move on to say something about the CICC's philosophy and the conceptual framework, and I will leave it to Jonas to speak about the visual elements, and I will focus just on the conceptual ones. The inspiration for the CICC is my book, What's Wrong with Right? Social Movements, Law, and Liberal Imaginations, published in 2018. That is where the story of CICC begins. But I am not going to speak about the book too much, except to say that it is a critique of liberalism as a philosophy, as the foundations of modern law, and as a political system. The CICC is informed by two main existential crises that has preoccupied us for some time now. The first is the ecological crisis, which is on our minds. And the second is the human migration crisis, whether this human migration is international or what is called internal displacement. The CICC sees the two crises as inextricably entwined, as two sides of the same existential question. When a corporation builds a large dam, funded by bilateral and multilateral aid and endorsed by the World Bank, the dam destroys ecology and communities who live on the land that is flooded by the dam. A founding principle of modern law concerns legal personality. And the two most important legal persons are states and corporations. The law says that there are two kinds of persons: a natural person, like all of us in this room, and a legal person, sometimes also called a corporate person or legal entities. The two most important legal persons in the modern world is, of course, states and corporations. Legal personality is based on what is called legal fictions in jurisprudence or legal theory. Legal fictions are just that, they're fictions. They invite us to pretend that the fiction is real, in the same way as children pretend to be mom and dad or teacher and student in their pretend games. A German philosopher, Weihinger, wrote a book called The Philosophy of As If, which is the philosophical foundation of modern societies. Let us pretend as if a corporation is a real person. And once you accept to play this game and pretend that it is real, the rest follows. The law invests these persons with all the human rights as if they were human. The right to property, right to free speech, right to organize, freedom of contract, everything that we have, the legal person has. The CICC says, let's take this seriously. Let's play the game. Yeah? And let's pretend as if these legal entities are also persons. And let us put them on trial for crimes against ecologies and communities, which is the two most existential question for us today. What becomes apparent when we see things in this way is this. Whereas crimes by natural persons, human beings, end with their lives. Once we are dead, if I'm dead, I can't commit murder anymore. But there is always hope for redemption with human beings, natural persons. But crimes by corporations and states have an intergenerational existence. They carry on generation after generation because their lives are eternal. They don't die. And they have no capacity for empathy with other beings or other species. These are human qualities that no law can endow on any legal person. You will hear more about these intergenerational climate crimes at the hearings tomorrow and on Sunday. But moving on, in our imaginaries, a court is established under some law, right? And it applies the law to the cases brought before it. This is what our legal imagination, this is what we have learned, that you go to a court and the court applies the law. What law does the CICC follow? And under what law was the CICC established? If the CICC followed the same law that the states and corporations have made, we will not have the same outcomes. We can't have a different outcome. My grandfather used to say that you cannot plant a pumpkin and expect to harvest a pineapple. You know, and this is that. If you take that law, that's the result you will get. We need to reimagine the law in new ways. So we wrote the Intergenerational Climate Crimes Act, and you read sections of it now, just before we started. And you have the text of the act in the program booklet if you want to have a closer look at it. The Intergenerational Climate Crimes Act 2021 redefines the meaning of climate crimes. That's the main thing. So not what the states and corporations say. We have to have our own definitions of climate crimes. The redefinition is captured in the motto of the court, and the motto of the court is intergenerational, interdependent, regenerational. Three key principles, which you will also see below the court's logo. The Intergenerational Climate Crimes Act 2021 expands the definition of climate to include not just more carbon molecules in the air or increases in temperatures, but it includes everything that prevents or becomes an obstacle to reproducing the conditions necessary for life for all species, any species. That's the challenge that we face today, is our inability to reproduce the conditions that are necessary for all life. That is the crisis. The Act sees human beings as one among many species. It de-recognizes fictitious people, fictitious persons, right? The Act sees corporations and states not as two distinct persons, as we are trained to believe, but rather as close collaborators and conspirators in crimes against ecologies and communities around the world. No corporation can exist without a state. No state can exist without a corporation. This is a given. It offers alternative imaginaries for reorganizing institutions based on ecological and communal solidarities. So what the other legal system does is looks at everything as things, as objects. What we say is we need to retrain our thinking and come to relationships and solidarities as the basis of any legal or new legal thinking. The Code for Intergenerational Climate Crimes follows all the rituals of the law. Law is, as many of you will know, is very performative. Right? It is full of rituals, it's full of theater, and the CICC follows all the rituals and all its performative elements. It is a court, there are judges, there are witnesses, there is a jury, there is the law, there is testimonies, there is everything that the judicial system has. There is even a clerk of the court, our very own Jonas Staal. But it infuses the rituals with new content. It does this so that we can reimagine another kind of law. You have all the ritualistic elements, but the content is completely different. The CICC project's aim is to expand legal imaginaries. So everyone, it's also a different kind of enactment, the substance. There are judges, but the CICC judges come from a long experience of struggle for justice. They are activists who know the lives of working people very intimately. We have the jury, but the jury is the public. Once they enter the court, as you will see tomorrow, their role changes to that of jury members who represent not their own interests or their interests of their communities or nations, but that they are present there as ancestors of future generations. Because that is what we are all of us are. We are ancestors for future generations that must come. There are images in the court, as you see, of these plants here, and in the other courts we have had animals, birds that were all made extinct since the beginning of colonization. Because the last round of extinction begins with colonization. Everyone, the plants, the animals, the people, the judges, and even the court clerk is a comrade in our court. If we are to turn away from proprietary ideas of things to relationship between people and between humans and non-humans, our language must also change. We need to practice seeing people and plants and animals as our comrades rather than commodities. Let me now go on to say something about the previous iterations before I come to this one. In all the iterations, we try to make the content relevant to the local context. The first iteration was in Amsterdam. And in Amsterdam, we put Dutch state and Dutch transnational corporations on trial for jointly collaborating in crimes against natures and people around the world. And this is because the court was sitting in the Netherlands. That was the context. And the Netherlands, as we know, is where modern corporate systems first begin. From bills of lading, promissory notes, shipping laws, and the extension of states' activities as a colonial enterprise began in the Netherlands. In Amsterdam, we put modern-day Dutch state on trial for establishing what the International Monetary Fund calls conduit states. States that act as conduits for so-called capital flows as enablers of transnational corporations that roam all over the world and pillage people and their environments. We put the law on trial through three corporations with Dutch nationality: Unilever, ING Group, and Airbus. We had witnesses testifying from 13 countries. We had Dutch prosecutors who were from campaign groups, NGOs, journalists, and between them, the cases covered the legal infrastructures for land confiscation, for financial expropriation, and war industries. We produced a verdict in all the 4 cases, something we know all courts must do. The verdict interprets the Intergenerational Climate Crimes Act and applies the act to the 4 cases. So there is a living development of what lawyers would call case law. The verdicts aim to provide clarity and guidance to activists, activist scholars, researchers, journalists, and others in their work. The second iteration was in Gwangju in the Republic of Korea, a city that drove the last nail on the coffin of dictatorship in Korea. In the Republic of Korea, we focused on militarism and wars as extinction wars. All wars destroy humans, non-humans, and the conditions necessary for life. Therefore, a climate crime is defined as such in the Intergenerational Climate Crimes Act. In Korea, we focused on the Korean state and the Korean corporation. So this was inward-looking, if you like, unlike in the Netherlands, because people of the Korean peninsula have lived under the shadows of war for nearly a century and continue to do so. The London iteration, about which I'll say something now, is the third major chapter. The previous iterations focused on climate crimes in the present. So what does Unilever do today? What does, in India, in Kenya, what do other corporations, ING, do in Indonesia, etc.? The witnesses in those cases testified to present wrongdoings by corporations and states. Their wrongdoings today, it became evident through the hearings, had much deeper roots in corporation-state alliances dating back to the colonial era. But the question before the CICC in those cases was limited to crimes in the present. If the corporation-state climate crimes against ecologies and communities were by their very nature intergenerational, as the witnesses in the Dutch and Korean cases told us, we felt it was necessary to focus specifically on the intergenerational aspects of crimes by states and corporations. The London chapter of the CICC aims to do that, focus specifically on intergenerational aspects of climate crimes. What are the vectors that carry these crimes from one generation to the next? What are the conduits for intergenerational transfers of criminality? The judges of the CICC felt that it was necessary to establish a special court that can focus specifically on intergenerational aspects of corporation-state crimes against ecologies and communities. Given the location of the special court in London, a city that in some ways the East India Company created after its own image as the hub where corporations and empires mixed and mingled, we felt that it was necessary to examine the systems of governance established by the East India Company and the British Crown to see how the corporation-state alliance can become carriers of crimes against ecologies and communities, if at all. More than any other corporation, the East India Company led the establishment of a system of governance that was and is still known in many parts of South Asia as the Company Raj. It was Company Raj because it was an entire system of governance. John Stuart Mill, the well-known British political philosopher, who had his office in London, not very far from here, and who was an official of the East India Company for 30 years, famously said that India was a great experimental laboratory for the empire. So governance mechanisms ranging from the protectorate systems, regime change, personal law, colonial constitutions, and much else that were developed in India were then exported around the British Empire. And therefore, the judges of the CICC determined that East India Company and the British Crown and their joint enterprise under the rubric of Company Raj was a good way to probe the vectors that carry climate crimes across generations, and London was an appropriate location to do that. Starting from tomorrow, the special court will hear 3 cases. The first one will be on the coming together of the British Crown and the British stockbrokers and merchants to establish this colonial enterprise and its system of governance. Is the colonial enterprise something in the past? Or is that also something that is carried forward one generation to the next? We will wait to hear from the witnesses tomorrow. The second case is on indigo, or Comrade Indigo, standing here behind me. Indigo trade was an important part of colonial trade from which the company and the crown profited, and which pioneered systematic exploitation of nature and people in the Indian subcontinent by introducing global trade in cash crops. The third case will focus on the indentured labor system, another crown company innovation with intergenerational consequences for land-people relationships. Although the starting point for indigo is a natural plant, as you see here in front of you, and for indentured labor is people, in the end, both starting points end in the rupture of land-people relationships. So whichever way you start. The terms of reference for the Special Court are set out in the Special Courts Act, Special Court on Intergenerational Climate Crime Act, and you should be able to read it if you wish to do so. It's all there in the booklet that you have, both the statutes and the Act. The Special Court on the East India Company will interrogate whether the corporation-state relationship is designed to perpetuate intergenerational climate crimes against ecologies and communities. Do they become vectors for the crime, and if so, how? The Special Court will examine the legal, institutional, ideological aspects of corporation-state relationships and their consequences for colonized humans and non-humans in the past, present, and the future. It will ask whether it is possible at all to sever the ties between corporations and states in the interest of future generations. Thus, the Special Court aims to connect the dots between the past, present, and future, and in so doing, probe the causes and effects of intergenerational aspects of climate crimes. I think I'll stop here and thank you all once again for your support and your enthusiasm, and hand you over to Jonas. Thank you.
Thank you so much, Radha. It's now a huge pleasure to welcome Jonas Staal to the stage, who's going to tell us about the visual aspects of this tribunal. Thank you.
Thank you so much, Lucia, for the introduction and the welcome. It's been an enormous pleasure to have worked with you these past 3 years, to have been in dialogue with you, to share imaginaries with you, to organize with you, and to build an ecosystem with you and with Radha and all of our teams. An ecosystem of thinkers, of organizers, of cultural workers that could propagate this court into being. I want to share with you a few notes on the visual conception of this space, on the visual organization of this space. We find ourselves here intraplanetary, meaning underneath the surface of central London in a former concrete testing facility. This is an image of its deeper past. Concrete is one of the most aggressive polluting industries in the world. It accounts for between 4 and 8% of global CO2 emissions. And as Diana Martinez argues in Concrete Colonialism, concrete did not just allow for the fortification of colonies, but also for an entire changing of land, an entire changing of ecosystem, to mold ecosystems after the interests of empire, as we see in occupied Palestine today. So it is in this space, in this intraplanetary space, in, beneath, with Earth, that Radha and I, many comrades and partners, aim to propagate the CICC, the Court for Intergenerational Climate Crimes, and just as our comrade Indigo here is propagating as we speak, throwing its seed pods around, we too are trying to propagate for a different law, a different legal imaginary. So our concept of law, our legal imaginary, Radha just introduced. It is a law of life, a conception of the law that aims at creating the conditions in which the mutual sustaining of life remains imaginable, remains possible. It's not the law that enabled the British East India Company to turn living worlds into empires' property, to turn a biosphere, a sphere of life, into a necrosphere, a sphere ruled by death. We built our law of life in defense of interdependency, intergenerational justice, regenerative politics, by prosecuting the state-corporate nexus. Now, across different iterations of the CICC, we aimed to build our courts not just to showcase evidence, but also to build them from evidence. And I'll get to the specifics of the evidence present in this space in a moment, but maybe to return to some of the previous iterations of the court. In 2021, we prosecuted various Dutch registered transnational corporations as well as the Dutch state in Amsterdam. And here, judges, prosecutors, witnesses were gathered around a pool of oil with an ammonite fossil placed in the middle. Literally the fossil inside of fossil fuels that reminds us that oil, fossil fuel, consists of millions of years of aggregated bodies of plants and animals, millions of years of earth memory, many of them from the Carboniferous, the geological era that literally holds carbon in its name. millions of years of earth work burned by fossil capitalism, leading to hypermobility in the present for some goods and for some people, but an omnicidal, not just a genocidal, but an omnicidal burning of living worlds for the global majority. The burning of all for the profits of an infinitely small elite. Now, ammonites were a family of octopus and squid that lived between 300 and 66 million years ago. They perished in the 5th mass extinction, and it might seem that human life and ammonite life, that our life and the lives of the fossils inside of fossil fuels has relatively little in common. But ammonite fossils were the witnesses of the 5th mass extinction, just as we are witnessing the 6th. They are fossils just as much as we are fossils in the making. Ammonite fossils are thus not only witnesses to interconnected extinctions, they are not only evidence of the reality of intergenerational earth work, they are, just as we are, earth workers. And our collective labor forms a profound intergenerational tie. In the second series of public hearings that the Court for Intergenerational Climate Crimes organized in Gwangju, we focused, as Radha said, on the relationship between climate catastrophe and the military-industrial complex. Now, as a whole, militaries are amongst the world's biggest consumers of fossil fuels. They account for at least 5.5% of global emissions, but this is it's really difficult to even put a count to that, because under the Kyoto Accord already the US negotiated that it wouldn't have to disclose the actual carbon footprint of its military apparatus. And in this case, we're only talking about the carbon footprint of the existence of the military-industrial complex. We're not talking about the ecological costs of waging war, which of course stands in an incalculable relationship to this already frightening number. So the military-industrial complex, its very existence is a climate crime. It's a crime against peoples and their natures, the way that Radha argues for nature not as an externality to humans, but as a relationship, as that what connects the threads, the web of solidarity across earth workers, across different workers of the biosphere. And in that light, the neoliberal embrace of the publicly funded arms race, including the UK Labour government, obviously only Labour in name, is truly and profoundly criminal. It's criminal because it sacrifices, as it has always done, young working class people for private profit, for industrial profit, but it's also criminal for its vast multi-generational ecological devastation. In Ukraine, in Kurdistan, in Palestine. So more than ever, it is time for a radical peace project, and the CICC stands with all those who demand the immediate expropriation and the immediate dismantling of the war machine. And in that light, the presence of large paintings depicting animals in the courts of Amsterdam and Gwangju are important to mention. Animals that were made extinct from the colonial period onwards. For it is here that, as Radha just said, we see the first waves of mass extinction of animal life, of plant life, as well as the making extinct of the human cultures that thrived with them. So we see the mass extinction of human languages, of human visual culture, with the forced death, the making extinct of these animals. Placed on a radiant yellow background, each of these non-human ancestors is termed comrade in a different, sometimes extinct or near extinct language. They are evidence of 500 years of extinction wars, from the genocides and ecocides committed by colonial armies then to the genocides and ecocides perpetuated in occupied Palestine today. They are evidence that colonial crimes are climate crimes and that the colonial era never truly ended. But these non-human ancestors are also more than evidence. They are earth workers, they are comrades with whom we share a common struggle, a struggle in defense of spheres of life against spheres of death. So that brings us to the question of what evidence is this court made of, where we find ourselves today, as we prepare to put the British East India Company on trial. There's evidence here of crimes, but there's also evidence of comradeship, evidence of a regenerative politics that connects us as intergenerational earth workers, and evidence that another law is possible, as already we were reading collectively fragments from the Intergenerational Climate Crimes Act. But let me start with the platform that we are standing on here. It's the shape of a wedge, which follows the exact dimensions of L. Lissitzky's poster work titled "Beat the Whites with the Red Wedge" from 1919, in which a red wedge penetrates a white circle that represents the Soviet revolutionaries beating back the Tsarist loyalists during the Russian Civil War. And that wedge represents a fundamental rupture in time, a rupture between capitalist prehistory, where we were nothing but the subjects of the church, of monopoly capitalism, and the possibility of a people's history. The possibility of a history in which people become the constructors of their own collective worlds. Now, for many, the industrial paradigm that is often associated with the Russian Revolution might seem oppositional or antithetical to the question of intergenerational climate justice. And of course, in the imaginary of the Soviet Revolution, the human worker, the human constructor, was always central, or was often central. But the moment that we begin imagining worlds based on a paradigm of radical equality, it is impossible for comradeship not to expand. It is impossible that it would be contained by human animals alone. And constructivist and productivist artists of the early years of the revolution, Popova, Stepanova, Rodchenko, Tatlin, they were already developing theories on the non-human comradeship of objects, such as here in the non-gendered clothing designs of Stepanova. So for them, for Popova, Stepanova, Rodchenko, Tatlin, it meant that the revolution did not just liberate people, it liberated things as well. Undone from their status as commodities, they now joined humans as fellow revolutionaries in their own right, or revolutionary objects and revolutionary humans together would come to construct, create entirely new subjectivities, like we see in the work of Klutzis, where Comrade Lenin and Comrade Electricity Mast, become an entirely new creature of its own. It is not Lenin, and it is no longer an electricity mast. It is something entirely different. This is the dialectic between revolutionary object and revolutionary human. So, non-human subjects are workers of the biosphere, just as human animals are. And our faith and well-being is inherently interconnected, is inherently interdependent from the inanimate work of mineral formation to bee pollination, or the work of proletarian plants, without which human-animal sustenance is impossible to imagine in the first place. So that means that we are all earth workers, and that this intimate shared earth work is what maintains a common sphere of life, a biosphere. That means that this wedge that I am now standing on is the wedge of earth workers. It represents ecological constructivism, the recognition that it is workers of all kinds and workers of all times that construct the living worlds as we know them. Now, of course, the actual power of this wedge is defined in part by the testimony and expert evidence that we will be hearing in the coming 2 days. Evidence that what we know as the law is itself a crime. Now, if we think of the fact that the multi-generational slow burning, slow drowning, slow suffocation that is the reality of climate catastrophe is legal. It's legal. It is according to the law. That makes the law itself a crime. But its force is equally defined by the presence of a fellow earth worker, and Lucia already recognized Comrade Indigo, Radha already recognized Comrade Indigo, is currently in the care of artist, plant stewards, and Comrade Rachel Pym, a descendant of the plants that were abducted by the British East India Company, placed in forced labor alongside enslaved human comrades. Ancestors of Comrades Indigo remain captive in the British East India Company Botanical Archives at Kew Gardens in London, and some of them appear around us. So, Comrade Gossypium arboreum, or cotton, Comrades Corchorus olitorius, or jute, Comrade Sagarum, or sugarcane, Comrades Papaver somniferum, or opium. Now, the reason why we name these earth workers as comrades first and foremost is because the names by which we commonly know them are the names enforced upon them through so-called colonial discovery. And this notion of discovery is itself, of course, profoundly violent, because it denies the fact that everything in this world already knows itself on its own terms and through its own communities. But it's violent especially because being discovered by empire means being enslaved by it, means being propagated by its will, means being made extinct. That means that colonial discovery is fundamentally a form of erasure. What they call discovery is, in reality, extermination. As you can see in the images of the comrades captured in the British East India Company archive, there are bandages, wires, broken lines in stalk and leaf, and these testify to the historical violence of this abduction, the ongoing violence of forced propagation in plantation-styled agro-business. But these earth workers stand here simultaneously in the yellow light of a regenerative politics, emerging not in forced horizontal position in their archival capture, not uncoupled from their relationship to the surface, to soil, but reaching from our shared ground upwards alongside their multi-generational descendant at the center of this court. The Court for Intergenerational Climate Crimes does not want to hide the historical and contemporary violences imposed on our fellow comrades. But neither do we wish to repress the force and the resilience of ancestral earth workers with whom we share struggle. So here we stand alongside one another the next days and many lifetimes after. We stand hand in hand in paw, paw in branch, branch in wind, wind in soil, in defense of a politics of life. In recognition that the law of life, the fundamental struggle of life to create the conditions to live, has and will always remain our horizon as earth workers, united in defense of living worlds for all. Thank you so much for being here, comrades, and I hope you join us the next days in the public jury.